Your Lordships have Rule 11, which gives the time limit of 15 days. And my lord, my respectful submission is, it may not be really feasible to say in black and white in what circumstances the speaker should or should not act. Normally, a person who's under a significant challenge should not act. If, my lord, a speaker, look at I mean, it's now academic, but the reason why we went to court is the speaker did not even give the period which you have to give for a reply under the rules. And it could be that the numbers were such that the speaker may have most probably lost his position. Because, my lord, one thing I do want to restate, I said this the other day. We know paragraph 3 about split has been deleted. One of the things which did prevail when your lordships upheld this law in Quixote as not being an anti-dissent but anti-defection law is that if there's a sizable number of breakaways, then it is not a defection. Then it is exercise, because one has to balance the right to dissent with.
But Mr. Sarve, then what is a sizable number of?
That's not for your lordships.
But then law will be bringing in split by the back door.
No, I'm sorry. I'm not inviting the court to do that. I'm saying something very different, Marathi. In fact, my respectful submission is your lordship has to take it as you find it. There was a provision for a split, which has now been deleted.
So therefore, the plain consequences that a split goes away.
No, I'm sorry, Marathi. I'm not saying to the contrary. Till
so
that
whether
law,
it's a 1/3 or a 2/3 or
is this to be ignored today? That's irrelevant. If you are found to have crossed the line, it doesn't help you to say that the number of people who crossed the line was more than 1/3. But whether that law, whether Quixote, because Mr. Sibal also said maybe someday Quixote will have to be relooked, maybe even on this Quixote will have to be relooked, because has this law crossed the line and become an anti-dissent law is something your lordship will consider if the law is challenged. Because one thing, my lord, which your lordships would consider, yes, we know there is a problem about political morality, but that problem is on both sides of the fence. It cannot be once you're in, you lock the barn doors. To say that a person becomes chief minister if his entire legislative party is rebelling against him, you must wait till he goes to the election commission, then they get the party split at the election commission level. And then what happens? I go to the election commission and say, we are the real party. You come and have all your legislative members disqualified because no split now. So you come to the speaker and say, my entire party is rebelled, throw everybody out. I'm the sole person, you can't remove me from chief ministership. Well, this is surely not what the law was meant to be. So all I'm saying is, yes, we know there is a problem. And the legislature has tried to address it by bringing in the 10th schedule to the extent it has. But this overstatement saying, because this is so, you must unscramble everything, you must transfer everything to Supreme Court. A resigned chief minister must be asked by a mandamus to come back and take office, or his accept of his resignation must be set aside. God knows what sort of reliefs have been asked for. So, my lord, my respectful submission is, and even as far as the governor is concerned, the solicitor is addressing your lordships. But since one of the issues does arise, is challenge to the governor's order. My lord, one thing which Bomai has laid down and laid down very clearly is that floor tests are not to be in Raj Bhavan, floor tests are to be in the assembly. Head counting is not to be done in Raj Bhavans because that is the root of a major evil. Whenever there is a question mark on the ability of the chief minister to command confidence of the house, the governor must call for a vote of confidence. Governor must not entertain people in Raj Bhavan and do head counting. Now that's the law your lordships have laid down to prevent politics from entering Raj Bhavan, if at all that is possible. So, my lord, when the governor calls for a vote of confidence, why should a chief minister continue in office even one day if he doesn't command the numbers? So yes, there is a problem of horse trading. But you are also leading a party. If there is a problem within your party, the problem is not only to be resolved in courts. So, my lord, my respectful submission is getting into this thicket, is inviting your lordships to depart from established constitutional principles which are judicially manageable. We have judicially manageable standards. Your lordships have said floor tests are the test. Let democracy play out in the floor of the house. That's a lodestar of this law. The governor did nothing wrong in calling for a floor test.
Yes, Kaushal.
Yes, ma'am. So, my lord, my
Yes, Council. Yes, yes.
yes. So, my lord, my respectful submission is on the three steps. As far as the Navam Rabia judgment is concerned, first of all, that question doesn't arise, and it's not a matter which is free from difficulties. But if your lordships are persuaded to get into, my lord, relooking that judgment, then there has to be some discipline. And that discipline can be brought in by a doctrine which we understand, and that's abuse of power. So, my lord, it's not absence of power, it's the manner of its exercise. And if in the facts of a case you find that there is abuse of power, a speaker has jumped the gun and done something which he shouldn't have, the courts are there to remedy it. So, my lord, that is the submission as far as Navam Rabia is concerned. Now, my lord, one other question which had come up, which I mentioned and your lordships are also seeing, can a mandamus issue to the governor to decide? My lord, that actually stands answered, because although it had been referred to 5 judges, a later judgment answers it, my lord, based on the observations in Rana. But on first principles also, my lord, there should be no difficulty. If your lordship sees the Quixote judgment on this, the problem which is sort of the genesis of this submission is paragraph 54 of Quixote, my lord. It's in the compilation, PDF page 111. The judgment's compilation, my lord. And the limitation on judicial review comes out of paragraph 7. And the question really is, my lord, in one sense, a mundane question. What is the meaning of the phrase quia timet action or an interlocutory intervention, which your lordships have said is not permissible?
54. 54 and 50.
Para 54, my lord.
So second compilation or third?
Second one.
Second.
Judgment 2.
Yeah, judgment 2, PDF page 111. Oh, that's at least the page which I have.
Oh, yes.
Volume 1 है, हाँ.
Volume 1.
Serial
Volume
number is Guru. Volume 1, serial number 2 is Guru Gobind Basu.
नहीं, नहीं.
Quixote. Yeah, it's serial number 6.
It is compilation volume 1.
Okay.
PDF page number.
PDF is page
51.
111. Para 54. And this is, my lord, discussing paragraph 7. Para 55, my lord, cites, in fact, the well-known rule in Maskin Company that this is to be strictly construed. And once your lordship has held that the speaker is a quasi-judicial tribunal, then, my lord, this has to apply in that sense. If your lordship sees para 62, in the present case, though the amendment does not bring directly any change in the language of 136, 226 and 227, however, in effect, para 7 curtails the operation of the articles and matters falling in 10 schedule. There is a change in so and so within the meaning of clause B of 368.2. Para 7 therefore attracts the passage having regard to the introduction of so and so, the 10 schedule, in effect, bring about a change in 136. So, my lord, it is in this context that your lordship said you cannot have a quietimate injunction in para 54. Now, today, my lord, law has moved far ahead, including, my lord, the proposition that even if by constitutional amendment you cannot water down to 26. We have had the later cases. But, my lord, I don't see this as a problem on the issue which your lordship is considering. The later judgment, where Justice Nariman has gone into the definitions, a 3-judge bench, my lord, 2020 SCC online, SC page 55. In this very bundle, your lordship will find it at page 1324.
It's 3024.
What's the cause title, Mr. Salve?
It is Kesham Meghchandra Singh and Speaker of Manipur.
Bookmark 32.
Some.
There are two, 31 and 32 both.
I think this is 32. 31 was the first one.
Right.
31.
Or is it 31?
Yeah.
It's a bench of 3 learned judges, man.
Yes, we do have.
What your lordships did in this case, because here this question came up, your lordship said we have referred it, but without noticing that the matter already stands answered by Rana. And the relevant passage straight away, if I may cut to the chase, but if your lordships come straight to page 1332 PDF, para 20, citing from Rana. In fact, my lord, if your lordship turns to page 1331, from para 15, your lordship starts citing Rana's judgment. And at the extract in para 17 of this judgment, which says after referring to the court's decision in Quixote and Ravi Nayak, in para 22, the court held Then in your lordships extract para 22. Suffice it to say, decision of the speaker on 6 September was not immune from challenge before the High Court in 226, 227. The court then went on to hold, then para 25. On the scheme of 102 and 191 of the 10th schedule, the determination of the question of split or merger cannot be divorced from the motion before the speaker seeking the disqualification of members, therefore not possible to accede that under 10th schedule, speaker has an independent power to decide that there has been a split or merger as contemplated by para 3 and 4. The power to recognize a separate group in parliament may rest with the speaker on the basis of rules of business, but that is different from saying that the power is available under the 10th schedule to the constitution independent of a claim being determined or a number of members had incurred disqualification. To that extent, the decision of the speaker on the hand cannot be considered to be an order in terms of the 10th schedule. The speaker has failed to decide the question he was called upon to decide by postponing a decision thereon. Well, this is the starting point of the proposition. Therefore, there is a failure to do your duty. It's a tribunal which fails to do the duty. Then, Malad, in the next para, about 6 or 7 lines, Malad, there is a line which is underscored and it says, the failure on the part of the speaker to decide the application seeking a disqualification cannot be said to be merely in the realm of procedure. It goes against the very constitutional scheme of adjudication contemplated by the 10th schedule read in the context of 102 and 191 of the Constitution. It also goes against the rules framed in that behalf and the procedure he was expected to follow. And then, my lord, your lordships, if your lordships turn to page 1332, the extracts in para 20 of your lordship's judgment, your lordship start by saying the court then adverted to the scope of judicial review being limited as was decided in Quixote as follows. And then, my lord, after those passages in Quixote, para 40 is set out, my lord, at the foot of that page, which says, coming now to the case in hand, it is clear speaker in the original order left the question of disqualification undecided. Thereby, he failed to exercise the jurisdiction conferred on him in para 6. Such a failure to exercise jurisdiction cannot held to be covered by the shield of para 6 of the schedule. He has also proceeded to accept that a split being merely on a claim, he has entered no finding of the split in the original party was prima facie proved or not. The action was apparently based on his understanding of his ratio of Nayak. He misunderstood the ratio. Now that we have approved the reasoning and approach of Jagjit Singh and the ratio is clear, it has to be held speaker has committed an error which goes to the root of the matter. So fundamental, even a limited judicial review has to be interfered with. Therefore, no hesitation in agreeing. In view of our conclusions above, nothing turns on the arguments urged on what were described as significant facts on the alleged belatedness of the amendment to the writ. It is indisputable order was originally subjected to the writ. Speaker specifically refrained from deciding the petition. On our reasoning, clearly there was an error which attracted the jurisdiction of the High Court in exercise of the power of judicial review. So your lordships have said failure to decide itself is a jurisdictional error which can be corrected under 226. Reviewed under 226. So this question already stands answered. And then in para 24, I want to take your lordship's time reading it beyond that one definition in blacks. A quietimate is because you fear or you apprehend. Now here there is no fear or apprehension, my lord. If a speaker is not deciding something, there is no fear or apprehension. It's an established fact. Then, my lord, para 29 and 32, and then I'm done with this, my lord. Para 29 is at the foot of page 1334. The reading of the decision shows that what was meant to be outside the pale of judicial review in para 110 of Quixote are quietimate actions in the sense of injunctions to prevent the speaker from making a decision on the ground of imminent apprehended danger, which will be irreparable in the sense that if the speaker proceeds to decide that a person be disqualified, he incurs the penalty of forfeiting his membership of the House for a long period. 110 and 111 of Quixote do not therefore in any manner interdict judicial review in aid of the Speaker arriving at a prompt decision as to the disqualification under the provision of the 10th schedule. Indeed, the Speaker, in acting as the tribunal under the 10th schedule, is bound to decide within a reasonable period. What is reasonable will depend on the facts of each case, but absent exceptional circumstances for which there is good reason, a period of 3 months from the date on which the petition is filed is the outer limit within which the disqualification filed before the Speaker must be decided if the constitutional objective of disqualifying persons who infracted the 10th schedule is to be adhered to. This period has been fixed keeping in mind that the ordinary life of the Lok Sabha and Legislative Assembly of the states is so and so, so and so. And then, my lord, finally, the foot of page 1335, para 32. My lord, after having held all this, please see what your lordships do. It is not possible to accede to Mr. Sibal's submission that the court issue a writ of quo warranto quashing the appointment of the respondent as a minister of a cabinet led by the BJP government. Mrs. Diwan is right in stating that a disqualification under the 10th schedule from being an MLA and consequently minister must first be decided by the exclusive authority in this behalf, namely the Speaker of the Manipur Legislative Assembly. It is also not be possible to accede to the argument that the disqualification petition be decided by this court in these appeals, given the inaction of the Speaker. It cannot be said that in the facts of the present case are similar to the Rana case. In the present case, the Legislative Assembly comes to an end in March 22, unlike the case, unlike in Rana, where the court, but for the court deciding the disqualification, no relief could have been given to the petitioner, etc. The only relief that can be given is that the Speaker be directed to decide the disqualification pending before him within a period of 4 weeks from the date on which the judgment is intimated to him. My lord, I commend this judgment for your lordship's acceptance. It's sound on principle, it's sound on logic. So, my lord, to close therefore, I start by saying, my lord, your lordship is being invited to embark on a journey which is entirely political in nature, my lord. It's a journey without a destination. And that journey is to speculate on what would have happened had a trust vote actually happened. Even in, because your lordships have never come to the conclusion, and I dare say your lordships never will, that the pendency of a challenge to somebody is continuing in the house renders that person legally disqualified until he's requalified by dismissal of a disqualification. So those, till your disqualification is decided, you are entitled to participate and vote. Yes, the system is not powerless. The courts are not powerless. If you find that a trust vote in fact was vitiated by the participation of a large number of people who 3 days later were disqualified, and what has happened is an abuse of the power and abuse of the constitutional provisions, the courts can always intervene. Now, my lord, today, apart from the figures which we have given to your lordships, the admitted position is there were 16 petitions on which notice was issued, and the gap was 58. Now, what would have happened? Forget this 58, my lord. This is also a coalition government. God knows what would have happened when the trust vote, if it had at all taken place. So, my lord, to invite your lordships to assume like a legal fiction that if the trust vote had happened and if these 20 had been left out, or these 32 had been left out, and then the balance would have had a change of heart, or something else would have happened, and then all these votes would have gone, and our coalition partners would have supported, and so would have won the trust vote. My lord, is a journey which your lordships would not embark on. Now, if I'm right there, then my lord, nothing survives in the first part of this case. The second part of this case is swearing in of Eknath Shinde. Now, my lord, what did the governor do wrong? A chief minister has resigned. He has to accept his resignation. Another person comes and says, I represent a party on which elections have, I represent a majority in the house. He goes. He has not won the majority. Now, if somebody says that he has won the majority by abuse of power because disqualification petitions are pending, those are matters yet to be resolved. How many numbers, how many are pending, what has happened to the disqualifications? And I do remember a lot before the former Chief Justice, because the tide had turned, as they say. And there were cross disqualification petitions against those who voted against the present incumbent. And they did also want the speaker to decide those disqualifications. So virtually there was, I remember in one of the hearings, the idea was don't aggravate things, let things lie. That's why things have not been decided. Your Lordship will direct in whatever reasonable time, the speaker will decide now all pending disqualifications. If somebody is dissatisfied, you have your remedies under Article 226 if the speaker gets it wrong. That's all that remains in this case now at this stage, is my respectful submission. So that's one broad submission. The second is, Malad, there is no occasion because this.
इसको बुलाइए
Oh, yeah.
दादा
Yes, Commissioner.
Yes, Mr.
The second, Malad, I was submitting, even this Navam Rabia, Malad, is a very thorny issue. But if your Lordships do get into it, then I have made my submission. Thirdly, Malad, there is no impediment in issuing any direction to the speaker to decide. And that's really where this case must now end. Your Lordship will direct the speaker within a defined period of time to, Malad, dispose of all pending cases, and the matter must end there. That, Malad, is the submission. Unless there's anything else I can assist your Lordship with.
Thank you, Mr. Sare. Thank you. Yes,
Please. As your Lordships were kind enough on the last day to permit me to sum up, because I had submitted my arguments, and I had also handed over to your Lordships three things, my lords. One was the judgments, which we had distinguished. The other was the timeline, my lords, with the crucial events as they unfolded. And the third was propositions and case law, which I have handed over. And then I had read out on the last day the crucial relevant paragraphs. Let me now just sum up some of the crucial events, because there's no point in my again getting into those timelines which your Lordships have read and reread again and again. And we both will have our side to say on the timelines, my lords. But firstly, it has been right through our contention that this is neither a case of merger or a case of split. Our case right through has been that a rival faction within the Shivsena is actually the Shivsena and is entitled to be recognized as the recognized political party under the symbols order para 15, which today has been accepted by the competent constitutional body, which is the Election Commission, and the matter is pending before your Lordships. Now, till 2nd of July 2022, the entire allegation was a para 218 10th schedule allegation that you have voluntarily given up the membership of the party. And why have you voluntarily given up the membership of the party? Because you failed to attend a meeting at a 2-day notice. You failed to attend a meeting for the same evening, and the other where we never got a notice. And then the speaker, contrary to the rules, gives us 2 days instead of what is provided for. And it is at that stage that we approach this honorable court saying, A, violation of principles of natural justice, B, threat to our life in the state concerned, and 3, relying on Nabam Rebia to say that constitutional propriety requires that the speaker should first decide his own removal before deciding disqualification. So, my lord, still second, it's only a 2-1A case. And our respectful submission is, my lords, that internal dissent is the essence of democracy. And in repeated judgments, your lordships have held that merely because within a party, people are aggrieved by what is happening, question the leader, question the chief minister, even from the same party, is not a 2-1A case at all. And that is exactly what your lordships held in Balachandra versus Yadurappa to say that even where from within the party, the chief minister of the same party was questioned as continuing, it was held that this was not a 2-1A case at all. So I don't have to rely on any defense at all of para 3 in any case which doesn't exist, or para 4. Because I am saying that as far as I'm concerned, this is the party, and I have been recognized today as the rival faction within the party. And definitely questioning and passing a resolution on the 21st, which categorically said that there is overwhelming resentment with the fact that we are continuing in a coalition, or were continuing in a coalition at that time, with a party which has been politically and ideologically opposed to us for decades, is causing great amount of resentment amongst the cadres and the party workers. So that is the resolution which reached the governor. Now, at this stage, my lords, so 2-1A, our respectful submission is this is not a case at all of a 2-1A case. In any case, my lords, whether it is a 2-1A case or a 2-1B case, who will decide that? The argument being raised before your lordship says these are per se cases. Because we say so, it is per se case, nothing else is required. And your lordship should bypass the entire constitutional machinery of coordinate constitutional authorities and decide it yourself, without the speaker having decided the issue. Because today we feel the speaker who ought to have been there is today not the only person. He's still the deputy speaker. There's a speaker in place who will be biased. So you decide the whole thing. This is the legal argument being made before your lordships. Contrary to every judgment on the point, including Quixote, that your lordships will not interfere till a final decision comes from the speaker on the point. Now, my lords, as far as the second part is concerned, which is 2-1B, which really commences on second, because then we are looking at two rival whips being issued. And our whip, as I had said, by an overwhelming majority of the legislature party had been appointed on 21st of June itself. They on the same date reiterated their faith in their earlier continuing whip. Now, the fundamental mistake in this argument is as if what is happening is only in the legislature party and not in the political party. And our argument on that, my lords, repeatedly has been that these are co-joined, integrally connected, organically connected, and each influences the other. And that is why, my lords, I had read out to my lords on the last date, even para 4 of Schedule 10, which categorically provided that a deeming fiction that for a merger of a political party, if 2/3 of the legislature party merges, that is taken as a merger of the political party, as an indicator that you can't segregate the two. Because this whole argument is based is that it's only the political party, it's only the legislature party, not the political party. We also draw strength on what we are saying, my lords, from the symbols order, which itself provides that for the continued recognition and existence of a political party, the number of votes polled, the number of MLAs and MPs which form the pool, are all part of the continuing existence and recognition of a political party. We We also draw sustenance for our argument from Sadiq Ali's paragraph that I had read out to your lordships on the last date to say that percentage of votes, number of MPs relying on the symbol orders is an important integral indicator for a continuance of a political party and is to be taken into account when the EC decides the matter. So, my lords, to say that you just represented the legislature party and not the political party is a complete fallacy and misreading of the law and facts, because this has been no one's case ever. In fact, our resolution consciously reflected the dissent within the party. The resolution did not say that it is just the legislature party. It talked about the political workers, the political party in question. Now, my lords, as a practice there, I had also respectfully shown to my lords on the last date the Maharashtra Legislative Assembly rules that at the end of the day, who is the speaker in touch with? The speaker is necessarily reliant, my lords, on the leader of the legislature party when it comes to recognizing a whip. Because under the rules, a member is elected as the leader of the legislature party. The legislature party's leader is the one who is in touch with the speaker. The leader of the legislature party indicates to the speaker the various designations and posts held by the people. The leader of the legislature party also indicates to the speaker under Rule 3, Subclause 4, any change which occurs. So today to say that the speaker in exercise of his power under Para 2(1)(b) of the 10th schedule will embark on an inquiry into the issues of the political party and will not confine himself what to the whip or the leader of the party says is wrong. Because A, he cannot do it, he doesn't have the wherewithal. A political party is a much larger amalgam of taluka leaders, of district workers, of political workers, of parties. It's the ECI, which is the constituted constitutional authority, which goes into it and has exercised its jurisdiction, was at that time wanting to exercise its jurisdiction when your lordships were asked to stay that. And your lordships refused that stay, saying that that order must come from them. So the speaker does not embark on that inquiry at all. Now, even when Para 3 existed, my lords, and I'm purposely now not getting into judgments again, even when Para 3 existed, my lords, in Rana, your lordship said two significant things. That the speaker will not embark on an independent inquiry as to a split in a political party. He holds the issue of disqualification. And as far as the issue of disqualification is concerned, it's a prima facie view that the speaker will take. Because what is being asked today is that the speaker will usurp a power that the speaker does not possess and will get into the politics of the political party. Of course, the first presumption being that they are two independent and thus an inquiry must be carried out there. Now, my lords, the practice of the legislature party of the Shivsena right through, my lords, has been, and those two letters have already been shown to my lords, also handed over. One is part of the record, the other was handed over, where it is always the legislature party or the leader of the legislature party which writes to the speaker to say who is the whip of the party. There is no doubt that an overwhelming MLA is the majority appointed Mr. Gogavle as the whip, and that the earlier whip was removed. There is no doubt about it. Now, today, we have a situation, even from 2nd of July, if it's a 2(1)(b) case, we have two rival whips issuing two rival directions, presuming they are right and there was a rival. So there are two rival whips as per them. Now, who will decide this? Again, the same argument of 2(1)(a). Your lordships are being told that per se, because we feel they have incurred disqualification, your lordships are not required to send it to anyone, and please decide it yourself. And that is a common thread that I'll keep coming back to, because your lordships are being asked, first your lordships are asked to bypass the election commission. which your lordships refused. Now your lordships are being asked to bypass the speaker, which your lordships have to consider. And the third issue is of the governor, which I'll touch upon separately, my lords. So three coordinate constitutional authorities vested with independent specific powers and areas of concern and interference which they have to deal with. The governor deals with, does the chief minister and the government enjoy a majority? Is there political accountability? Does he enjoy the majority on the floor of the house? As far,
Sorry for interrupting. See, the difficulty is rising because you're formulating this principle of prima facie determination by the speaker. So the defense that you would take as against a case of a split would be that there is actually a realignment of the political party and that you are the political party. Those defenses are all right, but we have to formulate the principle with respect to the decision that the speaker is going to take at this stage. As I was indicating earlier, it may be a jurisdictional fact. Here, the distinction between a split and the case that you set up, that it is actually a case where you control the political party, is very thin. So it's very easy for a speaker at one stage to say prima facie, I think that it is there, or very easily he can say prima facie, I don't think it's not a case. So to formulate that principle, that speaker will take a prima facie view and come to a conclusion that it is not a case of a split, but it is a case where you have set up the control over the political party. What are the contours of that? That's one aspect. Another aspect of it is that this being a jurisdictional fact, because if he comes to the conclusion prima facie that it is not a case of a split, but it's a case where you have the control of the political party, you go out of the 10th schedule. So there is severely contested by the other side. So this goes to judicial review on this very point, invariably, in reality. So the speaker has taken a prima facie view and adjourned the matter till determination by the election commission is what the order would be. So he says this can't be done, and according to it, the entire thing will revolve around numbers or the material that is there before the speaker to take that prima facie view. So it's a very slippery ground in that sense of now expecting the speaker to take a prima facie view and the kind of a material that is available for him to do it. And what kind of prima facie case? I mean, except that there are signatures, as in the case of about 34 MLAs. And aspects such as how much of the political party has vouchsafed for one group or not. How much would be available at that stage? So as a principle, I would take it that your submission is that he would only take a prima facie view and refrain from proceeding with 10th schedule, expecting that the election commission will determine the matter. And after the election commission says that it is not a case where the other group has control, matter comes back to the speaker and he will determine the case. That's the way you are
and just
hoping.
to add to it, my lords, because a constitution bench of this court in Rana has taken a view that you will not embark on an independent inquiry, dehorse disqualification, and a prima facie view. And prima facie view on split, yes. And I tell you, lordships, why? The speaker cannot get into something. The Election Commission of India has the machinery to determine that. But the other problem which also arises in this matter is, the lordships are right. There could be a problem, the peculiarities of a case. The problem arises also out of saying two distinct entities, the legislature and the political party. We are undermining the importance of overwhelming members of a legislature party, their resolutions passed, people supporting them, a competent body deciding on the issue. Because that is the only argument being made, that the speaker today should have gotten into it and should have not gone only by what the legislature party said. But that is a presumption that it's only the legislature party. That presumption in law is wrong, because it is never alone a legislature party. They're both integrally connected, organically connected, co-joined. You can't presume when you say that it's just one and not the other. And that is why from the symbol share order, dying to Sadiq Ali, everywhere, the word used is existence, recognition, continuance of political party. You fall back also, amongst other grounds, also on the percentage of votes, the MLAs, the MPs, and an indicator of it. And that's why I said, Manos, these are all indicators in furtherance of what we are arguing, including para 410 schedule. Now, Manos, that whole deeming fiction, why is it there? And in any case, my lords, to go back to what your lordships asked me, today the question is, will your lordships in a case like this get into and say that we'll decide it? Because because they say it's a per se case. So every second party will come to court and say it's a per se case as per us, and you don't need to go anywhere else. No other constitutional authority needs to get into it, and your lordship should act as the court of first instance and decide all these issues. So you are taking away and depriving every other competent coordinate constitutional authority of their jurisdiction and are being asked to act as the court of first instance in all these matters. And Rana, my lords, as I had submitted, was a completely different case. In fact, Justice Nariman, in the judgment which Mr. Salve also just read out, also deals with this issue, saying that for 4 years something was pending in the High Court. And then it came there. And then it was remanded back. It was being asked to be remanded back by the High Court. At that stage, the Supreme Court said the Assembly's term is coming to an end. So your lordships were said that it's been done. But when has it been done? In what circumstances has been done? Is the law of the land that all other authorities will be deprived of their jurisdictions? Because in the peculiar facts of Rana, it was said that court in a particular case could decide it in the manner it did. It can't be. Then, my lords, as I had respectfully submitted, the 2 letters I had pointed out to my lords, which clearly demonstrates a practice. Now, today to turn around and say, so when you issued the letters, it was fine. At that stage, the practice was fine. And necessarily, my lords, from the rules, as I said, that's the only way to do it. If a member of the leader of the legislature party has to be a member of the House, the rules say he will communicate. The rule says he will point out changes, he will point out designations. Disobedience of the whip, he will point out under Rule 3.5. Not those rules, I'm not rereading, my lords. I've taken my lords through each of those rules. Until unless your lordship so directs me, I'll read those rules. Is provided therein. So where will the speaker today embark on this independent inquiry on disobedience of the whip, etc.? It has to be within the contours of what the rules provide and the Constitution provides. Will he go and call members from everywhere, political party? And then the argument made to your lordships was that at that stage, only the leader of the political party should be in direct touch with. Can't be. We have to go by what the Constitution and the practicality says. If there are overwhelming majority today saying that we don't have a faith in the leader, let's test a proposition. Suppose an overwhelming members say we don't have the faith in the leader, but we want to be within the political party. So to say speaker will get into an area where a constitution bench says, yes, you will take a prima facie view. Now, those contours of how the speaker exercises jurisdiction will first be left to the speaker to exercise it. Because judicial review is always available to your lordships of a decision by the speaker. What contours, what standards, what principles the speaker follows. After all, in Quixote, that's why your lordships said no quo timid, no interim injunctions. Let an order come, then we'll examine it. And today your lordships are told that in the legislature party, this was only the legislature party, and they've hijacked the political party. And because the deputy speaker no longer, it's another speaker who's deciding, thus your lordships must decide it. That's the argument being made today. And it's a per se case. So all authorities, all principles be ignored because we say it's a per se case, your lordships must decide it. And because Rana had decided it. Then, my lords, another question that your lordships had earlier also posed to us, and today also your lordships posed to Mr. Salve also was on relating back and whether applying prospectively. Rana, as I had respectfully read out, was a decision where the Supreme Court exercised its jurisdiction to say that on the day disqualification was incurred, the split had not happened. The speaker went ahead with the split and not decided the disqualification issue. This court said, when it said it relates back ex post facto, the facts as far as disqualification are concerned will be seen on the date when they incur disqualification, not by subsequent split in the party that may have happened. That's an event wholly inconsequential for deciding disqualification. Ex post facto was used in that context. Now, that ex post facto is being used to argue before your lordships that if they are disqualified, it will relate back to the day they incurred disqualification, and thus all their exercise of votes, including the floor test vote, will be annulled and is vitiated. That's the argument being made before your lordships. Now, my lords, your lordships have repeatedly, from Kuldeep Bishnoi, Pratap Gowda Patil, Shivraj Chauhan, Nabam Rebia, repeatedly reiterated that till a disqualification petition is pending, an MLA has every, or an MP has every right to participate, whether it's for a floor test, whether it's for a disqualification, for a removal of a speaker, or in a floor test, has every right to participate. Now, if that is the law laid down by your lordships, how can it now be argued? And I showed my lords Shivraj Chauhan where exactly the same argument was made and rejected. And your lordships consciously talked about the 10th schedule being completely different from the other part. The two couldn't be mixed up. Now, I just come to that. Now, today, the same argument is being made to your lordships. So every bill, every apportionment, every decision taken will tomorrow be annulled, because as per them, the disqualification will relate back to the day you incurred it, and thus all decisions and participation in the House stand vitiated. What different?
Distinct trend.
Which one? You show me that line. Now, my lords, Shivraj Singh Chauhan, your lordships had consciously said, and categorically said so, that exercise of powers by the speaker to decide resignation or disqualification exists in a separate realm than a floor test. And the reason I pointed out, because my lord the Chief Justice had then said that could it be argued that that was a case only relating to resignation? And I respectfully submitted that no, your lordships did consider the issue of disqualification in the matter and floor test. You can't let the two be interfered with. Now, today your lordships are repeatedly said, thus, because it would be vitiated, the whole thing is annulled. And I'll come in the end, my lords, lastly, to what all your lordships are being asked to annul. That I'll come to as a consequence of once I complete all the acts which will flow in the waterfall as per them, which should be annulled. Because your lordships order led to the toppling of a government, which of course is another argument which I'll deal with. Now, my lords, Article 189, subclause 2 was respectfully read out to my lords, also for the same proposition
This will continue to be valid.
that even if a person voted who was ineligible, the votes will be continued to be counted. Again, in furtherance of the same argument that I'm making, that I'm drawing sustenance from. Also, my lords, Article 190, subclause 3, read with Article 191, says that vacancy arises when you incur disqualification. And when do you incur disqualification? You incur disqualification either under Article 191(1) or 191(2), which is a 10th schedule case. The Constitution does not say that the moment a disqualification is filed, a vacancy arises. Again, an indicator of the fact that till a decision is taken on the disqualification, how do you presume? And my lords, the dangers of that is that we will have today constituencies unrepresented in parliament and in the legislature because a disqualification petition is pending. That's one. Please see, for a bedrock of democracy where every constituency ought to be represented in parliament, we are being today told that because a disqualification petition is pending, should go unrepresented, a constituency, or
Mr. Call, if we accept your submission, in that case, suppose speaker doesn't decide it for number of years. There got 6 months or 8 months like observed by Justice Nariman in the judgment, correct? And what was observed by Justice Reyes Verma in that Coelho judgment. Correct? In between, correct? So many things happen. One thing, you can argue one thing, that whatever is in between decided on, correct, cannot be annulled, correct, or cannot be reverted back, correct, or cannot be recalled. But to say that the disqualification cannot be from the date on which the disqualification takes place, it will be too much to argue.
My lords, I did not for a minute, the Lords are absolutely right. I did not for a minute, did not say
So
that
it
he
will
will
be giving
No,
a
no, no, no.
premium to the inaction on the part of the speaker.
I'm not even saying that, my lords, because today on that, there is a complete answer in Rana. I'm not even saying that. I'm just saying till the disqualification order is passed and MLA continues with all the vigor and robustness and legality at its command under the Constitution to exercise his rights as an MLA or an MP. I'm not for a minute suggesting that ultimately if it's held in his against him, it cannot relate back to the day he incurred disqualification. That's very different, as your lordships rightly said, from in the meantime the actions which are taken. Because till then he is not disqualified. Till then there is no decision on it.
And he's
So
under the
that is why when I said it is prospective, is in that context I said. When the order is passed, it may relate to events which occurred earlier. The disqualification may be incurred on date A. The order of the speaker may be passed on date B, relying on an earlier event. But that's quite different from saying that in the meantime, all that has been done gets wiped away. That is the submission I'm dealing with, my lords. And if in that is why on the last date I had respectfully pointed out, look at the danger of this to a democracy. A minority government can continue indefinitely by having whoever is inconvenient to them filing disqualification petitions with no timeline of the speaker to decide it. Unlike a removal of a speaker, which I had respectfully submitted, has a timeline. And that is why one of the concerns of your lordships in this matter and other matters has been that there should be a timeline to the speaker also deciding on disqualification. So conveniently, there will be no floor test, or you'll continue as a minority government because whoever you feel will not vote with you, there will be a disqualification petition pending. Or as in Nabam Rebia, the Supreme Court dealt with and said that conveniently, because a speaker against whom a removal has been moved, you file disqualification petitions and none of them can vote. Now, today, in any case, in each of these scenarios, your lordships have already held, it's no longer res integra. Whether it's a floor test, whether it is a resignation, whether it is disqualification, anything. They said a member against whom a disqualification petition is pending participates. So these issues have been considered by your lordships. And ex post facto, as used in Rana, can never be interpreted to mean that that MLA or MP ceases to exercise validly his rights as an elected representative of the people. It was in that context, my lords, that I pointed out it's a danger to the bedrock of democracy that if a constituency goes unrepresented in the meantime, As far as a disqualification is concerned, my lords, that will ultimately can be rectified in judicial review. But what happens if you keep holding on to it without a timeline? And that's a very legitimate concern that your lordships have expressed about, can a speaker hold on to it and not decide at all? And that is what Justice Nariman, in that judgment, expressed his concern with, and said that as the court understood it, that matter actually stood answered in Rana. Because in Rana, ultimately, my lords, what did the court do? When the reference came in Sampath, Justice Nariman, in the later judgment of 2020, considered the issue and said that the very fact that in Rana the court interfered and said that you should have only looked at the decision and the facts as they existed on that date and no subsequent event, there was already an exercise of judicial review of a timely action by the speaker. Because what was the import in Rana? The import in Rana was that the speaker ought to have decided on the date the disqualification was incurred, and there was no indicator of any split in the party on 6th of September on that day in that matter. So Justice Nariman said that the very import of that decision in Rana is that you should have taken a prompt decision, which the speaker did not do, and thus the Supreme Court interfered in Rana in the manner. And then Justice Nariman went on to say that 3 months or 5 months would be 3 months would be an appropriate timeline. Because the life of the legislature is 5 years. And my lords, if your lordships, that para has been read out to your lordships, if I just, for a minute, without even troubling your lordships, the lines used were, has clearly been answered, stating that a failure to exercise jurisdiction vested in a speaker cannot be covered by the shield contained in paragraph 6 of the 10th schedule, and that when a speaker refrains from deciding a petition within a reasonable time, there was clearly an error which attracted jurisdiction of the High Court and exercise of power of judicial review. Because the speaker then, without deciding on it, sitting on it, went on to decide something else, which was the split. And the court said that something much later. You first decide on that particular day what happened. And in it, implicit was the argument, as the court said in this matter, in this Meghachandra Singh's matter, that implicit in it, in judicial review, was the fact that the speaker should have decided promptly. And the fact that speaker delayed that decision in Rana called for judicial review, and thus a time limit should be fixed. So my respectful submission on that would be, my lords, that even that very pertinent question of your lordships and that concern of a timeline today does stand answered in Meghachandra, irrespective of the Sampath Kumar reference which has been made. And in fact, my lords, even Sampath Kumar, in fact, my lords, even in Sampath Kumar, I'm not, if your lordships were to see, I'm not bothering your lordships with the order, but even there, while referring it to a larger bench, because Quixote was there, the Supreme Court said that if a decision of a speaker is subject to judicial review on disqualification, equally an indecision of the speaker would be subject to judicial review. So if a speaker decides to hold on and not decide, an indecision is equally susceptible to judicial review as a decision is, even while referring it to the larger bench, because what was concerning the court was Quixote. And then the court in Meghachandra explained it to say that Quixote was in the context of interlocutory injunctions, in the context of quid timit action, which was not the case where a speaker indefinitely sits on something and doesn't decide it. And that has its own consequences in politics and a parliamentary democracy. My lords,
He referred it in December 16.
please, my lords.
Justice Nariman referred it in 2016, December. for deciding this question, as he formulated, present petition raises a question of great constitutional importance, namely whether the Speaker of a Legislative Assembly acting under the powers granted to him under the 10th schedule of the Constitution can be ordered by the High Court exercising jurisdiction at 226 to decide a particular disqualification petition pending before him within a certain period of time. Directly the question. But then he decided that question having referred in December 16 and January 2020, Meghachandra answers the question. This reference is a two-judge bench. I think he is right in.
And he, my lords, refers to the facts of Rana. Because in Rana, the facts were that the speaker failed to exercise some jurisdiction which he ought to have exercised on that day, and went ahead and recognized the split in the party. And in that, Justice Nariman said, is implicit the fact that he ought to have decided that, and that decision itself, or indecision of not deciding.
So your submission is that in exceptional case only, like Rana, correct? The court may interfere at the stage of disqualification. Otherwise, it is to be left to the speaker.
My lords, I'm very grateful, and my respectful submission on that is this, my lords. Firstly, that's what the Constitution provides for in terms of the scheme. These are coordinate constitutional authorities to whom your lordships have given equal deference and respect as they have given to this honorable court. And there are jurisdictions carved out where they must exercise their jurisdiction, and the court does not act as a court of first instance in these matters. There may be a rarest of rare case where a term is coming to an end in 2 months, 3 months, and for 4 years it was pending in the High Court. And my lords, most importantly, in Rana, there was a decision of the speaker ultimately. Whether to remand or not was the case there, as far as the High Court was concerned. And then they said, let us decide it here. But that does not mean and cannot be stretched to an extent to say that your lordships will start deciding all this yourself. Then, my lords, as far as the issue of the governor's exercise of power is concerned, my lords, my respectful submission was, my lords, there were 3 important facts which were before the governor. 1, 7 independent MLAs withdrew support to the government.
Governor, Mr. Tushar Mehta.
Yeah, my lord, I'll just sum it up. I'll be the shortest on this point and then leave it to the learned solicitor. So,
You can just,
yes, so one was 7 independent MLAs.
just 1 second. Yes, what were you saying the governor had before him?
The cogent material, my lords, to call for a floor test is what your lordships are looking at, was 7 independent MLAs withdrew support to the government. 34 Shivsena MLAs sent a resolution where the party, the political party, as per them, and the legislature party reflected on and said that there's huge discontent within the party for politically opposed ideologies, discontent within party workers, large sections of the party, sent that, and the faith in the coalition government was doubted or questioned, any continuance with the coalition government. And thirdly, the leader of the opposition also notified the governor that the government in power did not enjoy the majority on the floor of the House. Now, my lords, in Bomai, your lordships have said any material or any process or means, of course it can't be extraneous, of course it can't be irrational. Any material, process or means can be used by the governor to come to the conclusion that a floor test is required. And the governor will not sit on his own and do a head counting in the Raj Bhavan. So the 2 or 3 principles which have emerged, my lords, is no head counting by the governor, prima facie view based on cogent material, and floor test at the earliest, because floor test is the litmus test of democracy and should brook no delay, as your lordships have said. And ordinarily do not give too much time to any political party, because then that whole problem of Aya Ram, Gaya Ram, horse trading starts. Now, what does the governor do in this case, my lords? A resolution with overwhelming members of the legislature party says that we have a problem with the coalition government. 7 independent MLAs say so in the case. Now, for him to tomorrow tell the chief minister to come and face the floor test, is this an exercise of his power without any material, so arbitrary? If at all, it can be argued that it's arbitrary, that your lordships will exercise your lordships' extraordinary jurisdiction to interfere with it. Or it's a plausible view that the governor could have taken in the facts of the case. If it's a plausible view that the governor could have taken in the facts of the case, and to say, my lords, and another argument was made was that he should have asked for a no confidence. But my lords, there's nothing in the constitution. Incumbent governments have been asked to face floor test, as we showed to your lordships in judgments. So to say it's never happened is wrong. And where is this rule that you should only ask the leader of the opposition or any other person to move a motion of no confidence? There is no legal prohibition. In fact, I would go to the extent of saying, my lords, if the governor is satisfied that a government has lost the majority on the floor of the House, it is the duty of the governor to call for a floor test at the earliest, and not indulge in head counting sitting in the Raj Bhavan. And that's all that he did. And the day he does it, a petition is filed.
Mr. Kaul, how many times has that power been properly exercised by a governor in some recent examples that we have seen?
Well, I'll find out. That's a.
It was the duty of the governor.
I will. But may I only answer that by saying 2 things? Well, no, one I'll give that. I'll just find that out. But I take it for a minute. It had never happened before. So what? If a governor is within his powers to do what he is doing, and there is no prohibition to what he is doing, he is not bound by just precedents. The law, Bomai says, any process or means and material. Now, if material is before the governor to come to this informed decision, what is wrong with it?
So what happens to abuse of power in that case of excess use of power?
That, my lords, in every case will see.
We're saying speaker's decisions are subject to judicial review, as you said, having acted or not acted.
And
both ways.
And then that is why I said what is to be seen is the material before him.
Right.
If according to us, if 7 independent MLAs, 34 or 51 MLAs with a resolution saying that we don't want to continue, what better indicator that a government does not enjoy the majority on the floor of the House ultimately? Now, again, the governor is not going to embark on the inquiry which the Election Commission embarks on. The problem here is that the speaker is being asked to embark on the inquiry which Election Commission embarks on. The governor is expected to embark on an inquiry which the Election Commission embarks on. Governor will look at the material placed before him, which is an overwhelming number of MPs who have been supporting the government earlier, right to say we don't support the government. He doesn't call upon and swear in anyone else into power. He asks you to face the floor test. And you know you don't have the majority. The moment you don't get the stay, you resign within 10 minutes of that order, which came that night. Within 10 minutes, you had resigned because you knew you did not enjoy the majority on the floor of the House. He did not directly swear in someone. Now, after that, if a coalition comes before him and says that he wants to stake a claim, and a coalition which actually was a pre-poll alliance earlier, what is wrong with it? Now, my lords, the next point for your lordship's kind consideration is that your lordship's order led to the toppling of the government. Firstly, all that your lordships did on 27th was extend the time, because the action of the speaker was in gross violation of the most elementary principles of natural justice, contrary to the Maharashtra Legislative Assembly rules, giving 2 days on a weekend to file a reply. We did argue Nabam, I've repeatedly said. We did argue natural justice, and we did argue threat to life. The court extended the time and also said protection to their life. to be given. Now, I go a step further, my lords. Suppose the court had relied and incorporated the Nabam principle in its order. What is wrong with it? Nabam till date holds the judicial field. Nabam is the law of the land. It's a constitution bench of this country, of the Supreme Court holding the decision. So if it had relied on Nabam also, there was nothing wrong with it. It was fully within its power and justified to use and rely on Nabam. And then to say that a government came to be toppled, because after that, because we are given more time, and the governor asks you to face the floor test, and you resign, because the stay is not granted by the Supreme Court. You say your Lordship's order of 27 toppled the government, because your Lordships had given more time, because had that time not been given, then the disqualification was per se would have been incurred in the meantime. That's the convoluted argument being made before your Lordships. That can never be so. Then, my lords, came the 29th order. Now, 29th order, my lords, when they came and said, apart from the fact that it said, subject to the proceedings on trust vote on 30th of June 2022, we argued that a floor test brooks no delay ought to be occurred at the earliest. In fact, the words used in Bumai are that a chief minister, the words used in Bumai are, a chief minister cannot shirk his responsibility to face a floor test. And if he refuses or shies away from a floor test, it's a prima facie view that he's not confident that he enjoys the majority in the House. So what did the governor do? Said face a floor test. The Supreme Court said, how can we stay a floor test? Because we keep coming back round and round to the same argument. Had disqualification been decided, had time not been given, then this would not have gone through. That's not the way. Firstly, a speaker will have to take a decision, and I came on principles of natural justice. The court said give them more time. How can you say a court order led to toppling of a government? And the 29th order specifically said that the proceedings of 30th are subject to court proceedings, but nothing happened because the chief minister had resigned. After that, fresh floor test was held a few days later, where overwhelmingly the new government and the new speaker were sworn in. The EC issue I'm not touching on. That 18th meeting relied on 27. That is wrong. They were independent meetings, and I haven't really gotten into the EC issues because your Lordship had so indicated. And we have right through said that all this had started on 21st, which was really a culmination of the dissent, brewing for a long time and ultimately culminated in that resolution on that day. And at appropriate times on 25th and 30th, when it suited them, they wrote to the same election commission and then came before your Lordships to say that no stay, the election commission should not exercise its jurisdiction. My lords, as far as the Nabam, give me the case law. No, this one. My lords, as far as the Nabam issue is concerned, my lords, again, that is something that I don't need to, we've addressed your Lordships extensively on. And the principal concern, my lords, there was one, and especially when para 238 onwards and Justice Mishra dealt with it, was that constitutional proprietary demands that after the introduction of the 10th schedule, if that speaker within the period of the notice and the date when it's actually held alters the pool, what happens? And they relied on what in the Constituent Assembly debates, including Dr. Ambedkar's reference to the 179C of the then members. The then member argument, my lords, even then emphasized on not just present on voting, but the emphasis was on the pool of the House. Now, that is the exact principle which Nabam also follows. That if between the day of the notice to the date when the resolution is moved, if you alter the pool, you do not then reflect the correct composition of the House, because you've altered it in a manner to suit yourself. And there is a conflict of interest as far as that is concerned. Now, my lords, an argument which was sought to be then made was that Article 181 provides that the Speaker cannot preside over the House only on the day of the resolution of the removal of the Speaker and not from the date of his removal as communicated. That was the argument on 181 made. But what is 181? 181 is also an argument to say that confidence, he can continue. But the danger, the flip side to it is, my lords, a speaker's election, if he proves his majority, is not questionable. But what is questionable is a disqualification at the end of the day. So they said that in a matter like this, first show your majority and then continue with it. So to say that the Constituent Assembly debates were to the contrary is wrong. Even in the Constituent Assembly debates, firstly, they were dealing with the removal of the Vice President and other issues. They weren't dealing with 10th schedule at all. There was no 10th schedule at that stage. The then members was interpreted in the context and to say that the House composition on the day the resolution is moved is in that context. To read the resolution is moved, and in Nabam the court was wrong in reading it from the day of the notice is completely wrong. Because if the court doesn't read it the way the court has read, as the court has said that this would have led in a matter like this to sustain a robust vitality of the growing constitution were the words used, and to avoid any conflict of interest. This would be the most appropriate constitutional and ethical argument to tell the speaker to do it in a time-bound manner as far as you are concerned, and then go ahead with it. So my respectful submission is, my lords, Nabam requires no reference, lays down the correct law, requires no reference to a larger bench. Now, my lords, lastly, to end, my case law note is already with your lordships on each of the propositions I have given. So, my lords, effectively, everything that is annulled is their argument. And Mr. Thackeray's voluntary resignation should not have been accepted because he resigned, he should not have been, they should have continued. The governor should not have acted in his constitutional capacity to invite the largest party as it then saw, or the coalition, to come and form a government. The confidence motion in the House reiterating overwhelmingly the faith in the new government and the new speaker needs to be reversed. The governor ought not to have administered the oath of office to Mr. Shinde. The speaker ought not to have been elected by the House, not once. Confidence reinforced in him again. So everything needs to be annulled because everything relates back to that one day when disqualification was incurred, and because the speaker was not, or the deputy speaker was not allowed to decide that, everything that has happened is vitiated. And in the process, whether you refuse to face the floor test, you did not have the confidence of the House, is all immaterial. And a government which overwhelmingly proves its majority, everything should be annulled. And despite all the law that your lordships have laid down, that every member is entitled to vote on the floor of the House, irrespective of the disqualification pending, should all be ignored. My lords, in Navam, I must also lastly point out to your lordships, subject to correction, I am instructed to say that apparently a review was also filed against the judgment in Navam, raising the same grounds of challenge. And it also raises the same interpretation of all the then members to be the date on which the vote takes place, and the Article 181 argument, and that review was also dismissed. Now, my lords, is it fair to re-agitate the same issue all over again before another constitution bench is another argument for your lordships' kind consideration? My lords, I'm extremely grateful. Your lordships are kind enough to call upon me again. I'm very grateful for that.
Thank you, Mr. Cole.
I'm very
Yes,
grateful.
Mr. Jethwani.
Lords, I have a note, which is note K in your lordship's record.
Jethmalani, we have 44 files on PDF, all part of the written compilation.
Well, I empathize with your lordships, but it's just note K.
Written on behalf of OCX, last one. कितने page हैं? 17 pages. 17 pages?
But there's no PDF. I'm told there's no PDF.
17 pages.
It's
17 pages.
K.
K, na?
It's a separate document. But
It's a 7-page document.
it's,
It's a
it's a
7
separate document marked note K. I would, for the sake of saving time, I would run through that note a little bit so if your lordships could have it. Lordships got it?
I think we can run through the seven.
Now, that it's tried to state that every case depends to a large extent on its own facts. Now, my learned friends have taken recourse to some facts, but I propose to deal more substantially with facts and only incidentally with the law, because a lot has been said on the law. To point out, my lord, that the fundamental propositions of law which my learned friends have raised in this case, on the facts of this case, don't arise at all. But Mr. Salve has said something on it in his brief submission. I'll just expand a little on it. But essentially, the 2 points of law, as I understand, in sum and substance, what it boils down to is A, the question of deemed disqualification, but to use that term which they've sometimes used and sometimes steered away from. The question of deemed disqualification, i.e., they were liable to disqualification. Disqualification never took actual place, but they were liable to be disqualified. And consequently, as a result of that deemed disqualification, the second proposition of law, and that is that the court must set the clock back, relying mainly on Rana, again extensively dealt with by my learned friends, Mr. Salve and Mr. Kaul, and set the clock back completely, because the concept of deemed disqualification, since it dates to the date when the acts entailing disqualification took place, are the ones that are relevant for the purpose of disqualification. So you must look at that time. Now, a brief conspectus of facts. Now, as I pointed out earlier, when we were dealing with referral, there's a very short time span, and that's between 21st and the 4th. Now, it's important to note that while discontentment and division commenced from the very inception of the post-poll alliance of the MVA government, the commencement of irreconcilable differences occurred on 21st June. That's the first date. The differences chiefly centered around the disinclination to continue with the MVA alliance, which, as per the Eknath Shinde group, was causing serious turbulence among party cadres for two reasons. The Shivsena had entered into a pre-poll alliance with the BJP for the elections held in November 2019, and their voters and cadres were aggrieved by the betrayal of that pre-poll alliance by the constitution of the MVA coalition government, and two, that the party cadres were finding it difficult to reconcile long-standing ideological battles with their coalition partners, namely the Congress and the NCP, and the cadres of the different party in the coalition, far from working in cohesion, were at loggerheads with one another. Now, there are many statements even before the 21st. Ministers of the then Shivsena, the joint Shivsena, many statements expressing dissatisfaction in public. MLAs have complained about it. So this is all, 2021st is the only date which this court has a record of. But it happened much earlier. Now, the first steps, as per the record of this court, that led to the rendering the differences irreconcilable were admittedly initiated by the Uddhav Thackeray group. One of the first salvo was filed on 21st June by the Uddhav Thackeray group. In its resolution of 21st June 2022, a minority of members of the Shivsena Legislative Party in the Assembly removed Eknath Shinde from the post of Group of Shivsena Legislative Party, of leader of the Shivsena Legislative Party. On the same day, the Chief Whip, one Sunil Prabhu, issued a party whip summoning all members of the Shivsena Legislative Party to attend the meeting at the CM's residence on the same day. The removal of Eknath Shinde, this is where it starts, because my Lord Justice Kohli was asking about, could there be no reconciliation? Was there no party forum to resolve these differences? The first salvo that was filed was on 21st June, and it was a very drastic salvo filed. The salvo was you remove him as a legislative leader. After that, it became irreconcilable. Nothing could be done. And I'll tell your Lordship what happened afterwards. Those facts are very important as to why the party forums became irrelevant. What was done by the party organization and the party leaders, including people in their party leaders in parliament. The removal of Eknath Shinde as a leader of the legislative party indicated an intention on the part of the Uddhav Thackeray faction to escalate a simmering dispute to a point of no return. Now, neither the resolution nor the whip issued by the Chief Whip were communicated to any of the Shivsena MLAs who were not signatories to the resolution. Eknath Shinde and the other MLAs only learnt about the resolution and the whip on 21st June through media reports of the same day. On its part, the Eknath Shinde group, consisting of 34 MLAs, passed a resolution on the same day setting out various grievances with the party leadership for forming the MVA government and the impact that it had on the party, its organization, cadre, and voters. Now, my Lord, all this has been read, so I'm not going to read in detail. But, my Lord, your Lordships will recall that the letter of 21st June was a response by Eknath Shinde to his removal, in which he pointed out that it was not just the legislators, but it was also the cadres who were disappointed. So the organizational disappointment along with the legislator disappointment were both highlighted in that letter of 21st June, which, as I said, was a response to their letter. By the resolution, 34 MLAs reaffirmed Shinde as the leader of the Shivsena Legislative Party, removed Sunil Prabhu as the Chief Whip with immediate effect, and appointed Mr. Bharat Gogable as Chief Whip in his place. The resolution was sent, this is important, my Lord, the resolution was sent and received by the Governor of Maharashtra. So the Governor of Maharashtra, to answer again, my Lord Justice Kohli's, had his first intimation of a simmering dispute on the 21st June. The resolution was sent and received by the Governor of Maharashtra, the Deputy Speaker of the Legislative Assembly, and the Secretary of the Maharashtra Legislative Assembly, both by email and a hard copy. And the rule and the article are both mentioned in that letter sent to the Governor and the Deputy Speaker, on the ground that he no longer enjoys the support of the majority of the House and accordingly has lost his right to continue as Deputy Speaker. In view of the decision in Navamrevia, the Deputy Speaker was requested to refrain from acting as Deputy Speaker till such time as he could prove the support of the majority in the House. Now, my lord, what are the contentions of the petitioner? First, that if the respondent had a grievance with the party leadership, he ought to have sorted it out within the party and not sent the notice under Article 179C to the Deputy Speaker. That the notice of the Deputy Speaker was flawed because in any event, the Deputy Speaker's disability under Article 181 commenced on a consideration of the notice of a resolution was removal and not when notice had been given of the intention to move the resolution under Article 179C. The decision of Navamrevia to the contrary needed reconsideration. And the resolution of 34 MLAs of Eknath Shinde group was without jurisdiction as Eknath Shinde. A letter to the Deputy Speaker under Article 179C was a protective step against any escalation by the Uddhav Thackeray group. Significantly, at this stage, now this is important, the Eknath Shinde group did not take any step in the direction of unsettling the government by withdrawal of its support, necessitating a floor test. Now, my lord, on the applicability of Navamrevia. Although on facts, it's my respectful submission that Navamrevia's, the case doesn't arise at all on the facts of this case. Nevertheless, my lord, if your lordships do intend to say something about Navamrevia, my lord, this is my respectful submission that it should be to reaffirm, especially Justice Mishra's view. My lord, I concede that the then members' part of 179C has been wrongly construed, particularly in view of the Constituent Assembly debates and particularly the view of Dr. Ambedkar in that. But my lord, there's much more to be said apart from the then members' part of it for reaffirming Justice Mishra's very eloquently put view in that separate judgment. On the applicability of Navamrevia, the construction of that judgment regarding the time when the Speaker's disability under Article 181 commences was established law by a constitution bench, and the Deputy Speaker was bound to act according to its dictates. Well, that's an aside. In any event, whether you like Navamrevia or not, the Deputy Speaker was bound by its mandate, and its disobedience at that particular point of time is a serious breach on his part of his duties and the role envisaged for him by the Constitution, impartiality, and of course, obedience to the law. As regards the correctness of the view taken on this aspect in the decision in the Navamrevia, it is respectfully submitted that this honorable court should reaffirm the view in Navam, most emphatically enunciated by Justice Mishra, that when there is an expression of intention to move a resolution. Now, may I just read paragraphs 236 and 238 of Justice Mishra, just 3 paragraphs at this stage. It's PDF 1167. Because my lord, he makes the case for what he says compelling. (236). In this regard, lordships, it is essential to understand the character of the 10th schedule. The 10th schedule to the Constitution has conferred adjudicatory powers on the Speaker. While deliberating on the constitutionality of said schedule, the majority in Kyoto's case has stated, the Speaker Chairman, while exercising powers and discharging functions under the 10th schedule, act as tribunal adjudicating rights and obligations under the 10th schedule, and their decisions in that capacity are amenable to judicial review. However, having regard to the constitutional scheme of the 10th schedule, judicial review should not cover any stage prior to the making of a decision by the Speaker's chairman. Having regard to the constitutional intent and the status of the repository of the adjudicatory power, no quia timet injunction actions are permissible Now, I'm not pausing there for a minute. If there is a constitutional violation by the Speaker, the actual order of disqualification, that is not contemplated by Kyoto's judgment. For instance, when he did not comply with the notice period, and that notice period is under Rule 8 of the 10th schedule, a court could intervene because that was a denial not only of natural justice, but a contradiction of the rules framed by them in their wisdom under Rule 8, under Clause 8 of the 10th schedule. And Kyoto says something about the sanctity of those rules. I'll come to that later. At para 6.1 of the 10th schedule, to the extent it seeks to impart finality of the decision of the Speaker's chairman is valid, but the concept of statutory finality embodied in paragraph 6.1 does not detract from the abrogate judicial review under Articles 136, 226, 227 of the Constitution, insofar as infirmities based on violations of constitutional mandates, malafide, non-compliance with rules of justice, and perversity are concerned. But Kyoto says more on paragraph 8 rules, and I'll come to that. Now, note that the rest of that is, you'll also just see J, that contention that the investiture of adjudicatory functions in the Speaker's chairman would by itself vitiate the provision of the ground of likelihood of political bias is unsound and is rejected. The Speaker chairman hold a pivotal position in the scheme of parliamentary democracy and are guardians of the rights and privileges of the House. They are expected to and do take far-reaching decisions in the functioning of parliamentary democracy. Vestiture of power to adjudicate questions under the 10th schedule in such constitutional functioning should not be considered exceptionally. Now comes Justice Mishra's own enunciation. The aforesaid reasoning eloquently speaks of the power, position, and the status the office of the Speaker enjoys under the Constitution. It also states about the scope of the fiction. The court has constricted the power of judicial review and restricted it to the stage, carving out certain extreme exceptions. It is because the Speaker, while exercising the authority stroke jurisdiction, exercises the power of constitutional adjudication. The concept of constitutional adjudication has constitutional value in a parliamentary democracy, and constitutional values sustain democracy in a sovereign republic. The Speaker is expected to maintain propriety as an adjudicator. My Lord, when I show the facts of this case as subsequently transpired, I will show your lordships that the Speaker repeatedly violated his constitutional duty as envisaged. The Speaker, when functions as a tribunal, has the jurisdiction authority to pass adverse orders. It is therefore required that his conduct should not only be impartial, but such impartiality should be perceptible.
That's all right.
Not
We've seen the rule.
We have seen Rule 11.
So now in short, my Lord, he has to give a notice 14 days period, and then as soon as may be. But the House rules make it almost impossible for there to be any serious delay in the matter pertaining to disposal of this issue of his removal. Because it's only that 14-day period. Immediately after the 14-day period, he has to refer it to the House. And then, so basically it's 14 days. And
So according to the prohibition, the period when the Speaker is
then the provisions of Article 181 of the Constitution are based upon the rule against one being a judge in one's own cause. In other words, the nemo judex in cause sua rule. There is no reason why this rule should be restricted to the case of consideration of resolution, but not at the stage of notice, when a speaker who continues to function as a speaker can use his powers as a speaker to alter the constituency that will decide on his removal. So he can gerrymander the constituency that decides on whether he should, if he's allowed to remove them. And that's the whole purpose of. Well, Lordship will kindly have, what is it that is prevented by 179 or 181? It is that the speaker cannot preside. He cannot preside over the house. That word is important. By presiding over the house, he gets several powers, which can, my lord, and his powers, at least under our constitution, are almost paramount. They're unchecked. His is the last word. Regarding procedure in the house and decisions taken, his is the final word. There's no check on it within the house. It's only governed by the rules. That's it. Now, my lord, your lordship, may quickly see two rules which have not been pointed out so far. Rules 53 and 58 of the Maharashtra Assembly Rules, PDF 34 and compilation 3C.
The PDF page?
PDF 34. 34. I know that it is the possible abuse of his power to preside that has warranted 181, that has brought 181 into existence. Now, under Rule 53, for instance, I'm just giving an example as to what he can do to scuttle the constituency, to scuttle the number of members who might vote against him. The speaker may direct any member who refuses to obey his decision or whose conduct is in his opinion grossly disorderly to withdraw immediately from the assembly, and any member so ordered to withdraw shall do so forthwith and shall absent himself during the remainder of the day's meeting. Now, this is a part of suspension, essentially. So on that day, on a particular day when he's being voted, he can resort to this power and there's no check. That is why his powers of presiding over the house are suspended when his motion is under consideration for his removal. Now, my lord, by a parity of reasoning, what applies here should equally apply to that 14-day period, because he can scuttle members during that time. In fact, as happened in this case, he can totally ignore the notice at all. A speaker prone to doing that, as he has done in this case, can well not scuttle the entire removal procedure. Now, I'll briefly remind your lordship at the appropriate time as to what he did in this case. So, for logical reasons, there is no ground to distinguish between the 181 stage and the 179 stage. The nemo judex rule will and must apply at both stages. Otherwise, you check him at the 179 stage, but he can scuttle the entire removal motion at the 14-day period 179 stage. '58 is an all. 58 of the rules is his residual power. He is the final residuary authority of all power in the House. All matters not specifically provided for in these rules and all questions relating to the detailed working of these rules shall be regulated in such manner as the Speaker may from time to time direct. So anything that's not provided for in the rules is at his sole discretion. That's how powerful he is. Now, my lords, that's the proposition. The proposition is that the judgment in Nabam Rabia must be reaffirmed and put on stronger ground for the reasons I respectfully submit I have advanced in this note. There may be something to say about the then member's part, but there are stronger grounds This judgment can be put, this authority can be put on stronger grounds if your lordships are to revisit the judgment. Now, I come to the next factual conspectus, and that is now on 22nd June. On 22nd, Prabhu, acting as chief whip of the Shivsena legislature party, issued a notice calling all members of the SSLP to attend a meeting to be held at the CM's residence on the very same day at 5 p.m., failing which consequential action against the delinquent MLAs under the relevant provisions of the Constitution of India would be taken recourse to. The said letter was replied by Shri Eknath Shinde on the same day, disputing the authority of Sunil Prabhu and further stating that Bharat Gogwavle had been appointed the chief whip of the SSLP. It was also said in the same letter that the notice was invalid, PDF, page 51. In view of non-attendance by Shinde and other MLAs of the Shiv Sena, an illegal resolution was passed. Now, please note, they didn't attend that meeting. For that very elementary ground, a notice was then issued. A resolution was passed by 14 MLAs of the UT faction to take disciplinary action as provided under. So this is the starting point. Disciplinary action under 10th schedule.